everyone, and welcome to Uncivil Law. I hope you're having a great day. And today we have a case of a cop behaving badly, drunkenly, and stupidly. This is a case of Hein Ju Park versus the city and county of Honolulu. In this case, a cop went to a bar with his firearm and then decided to pull his firearm out in order to check to see whether or not it was loaded. It was! And he accidentally shot someone who was hurt as a result. So this person is suing for the damages that was caused to them by this drunk cop pulling out their gun to make sure it was loaded and pulling the trigger and yeah, okay, let's read on. Juan Hu Park used to work as a bartender at a sports bar in Honolulu, Hawaii. Late one night, when Park was working, 3 off-duty police officers employed by the Honolulu Police Department stopped by at the bar for drinks. After consuming 7 beers over the course of 2 hours, one of the officers, Anson Kirma, decided to inspect his personal revolver, which the department had authorized him to carry. He apparently did so to ensure that it was loaded, because that seems like a good idea. The other 2 officers, Sterling Naki and Joshua Osamoa, watched as their intoxicated colleague recklessly attempted to load his already loaded fire. Kirma's revolver accidentally discharged, and a single bullet struck Park. She suffered serious life-sustaining injuries as a result. Park filed this action against the 3 officers and the city and county of Honolulu under 1983, our favorite law here on Uncivil Law, and the Hawaii state law. In the Second Amendment of complaint, Park alleges the defendants violated her substantive due process rights to bodily integrity under the 14th Amendment. As to the individual officers, Park alleges the Kirmu's reckless handling of the firearm exhibited deliberate indifference to personal safety, and that Naki and Osamo are liable for failing to intervene to stop the dangerous conduct. As a basis for establishing this county's liability under the Monell Doctrine, Park alleges that the 2 Honolulu Police Department policies or customs caused the injuries. First, Park alleges that at the time of the incident, Honolulu Police Department Policy 2.38 requires off-duty officers to carry a firearm at all times, except when an officer's physical and/or mental processes are impaired because of consumption of alcohol. Which, presumably would be like now, for example. But yeah, and interesting, under Monell, for example, in case you're wondering why they're mentioning the case, in order to have liability against the government, to have liability against the officer, you need to show a violation of 1983 for a well-established right. We've covered this many, many times, right? To show for the government, to show for the police officer, to show government as a whole, you need to show some sort of policy or procedure or practice that caused this to be. So there's no vicarious liability, no transferable liability under 1983. So you can only get liability against the police officers, department, or against the government, the state, if you can show a policy, procedure, practice that caused this to occur. So that's what they're talking about, this Monell Doctrine. So they're saying, under this policy you have, this is one of your policies, procedures, practices that requires you to have a handgun. So therefore, I've shown the hook. Okay, let's go on. Second, Park alleges that the Honolulu Police Department tacitly promoted a brotherhood culture of silence. A police department with a brotherhood culture of silence? No. That condoned police misconduct and affirmatively discouraged other officers from reporting on transgressions. We've never heard of any such thing here at Uncivil Law ever. Yeah. Park settled her claim against Kimura early on, and he's no longer proceeding, so he settled. That's nice. The remaining defendants, Naki, Osamo, and the county, moved to dismiss the amended complaint under the civil laws procedure. The district court granted the motion as to 1983 and declined to exercise any supplemental claim for any state law claims. So there's some state law claims that might apply, but go figure those out in state court. So on appeal, Park urges them to reinstate the 1983 claim. We review de novo the dismissal of the complaint under the motion to dismiss. Section 1983, everyone's favorite law here, provides a cause of action against every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws of the United States. To state a claim under this provision, Park must allege she suffered deprivation of federally protected right and that the alleged deprivation was committed by a person acting under the color of state law. Our circuit has developed a 3-part test for determining whether a police officer, while not on duty, has acted under color of law. The officer must have acted or pretended to act in performance of official duties, invoked his status as a law enforcement officer with purpose and effect of influencing behavior, and engaged in conduct that is related in some meaningful way either to the officer's governmental status or the performance of duties. Park's claims against Naki and Osamo fail at the first step. Yeah, so once again, some police officers get away with, okay, just to make sure we're all clear on what's happening here. The officers weren't like doing anything wrong when they saw their drunk colleague pull out the revolver and try to load it, and then they didn't try to intervene or stop, and it's totally okay or something, I guess. All right. The complaint is not plausibly alleged that either officer was exercising or purporting to exercise official responsibility during the events that led to the injuries. Both officers were off duty and dressed in plain clothes, drinking and socializing at a bar in their capacity as private citizens with loaded firearms. They never identified themselves as officers, displayed their badges, or specifically associated their action with law enforcement. Park alleges that, although Naki and Osamo were off duty and present at the bar in their capacity as a private citizen, everything changed when they saw Kimura pull out his firearm. According to the complaint, Naki and Osamo became effectively on duty at that moment, even as the Honolulu Police Department requires its off-duty officers to affirmatively protect the community when dangerous situations arise in their presence. But, as our cases make clear, the critical question is not whether the officers were technically on or off duty, but instead whether they exhibited sufficient indicia of state authority for us to conclude that they were acting in official capacity. Because Naki and Osamo did not act or purport to act in performance of their duties, they were not acting under the color of law. We accordingly affirm the district court's dismissal of the complaints against Naki and Osamo. With the complaints against these two fellow officers out of the way, who did nothing wrong by watching their fellow officer load an already loaded revolver after drinking at a bar and shooting someone, we must then turn to the government as a whole. Is the county or the state or the police headquarters or someone else responsible for the training and neglect? Let's read on. The remaining question is whether Park has plausibly alleged a claim against the county. A municipality may be held liable as a person under 42 U.S.C. 1983 when it maintains a policy or custom that causes the deprivation of plaintiffs' federally protected rights. To state such a claim, a plaintiff must allege that a particular municipal action itself violates federal law or directs an employee to do so, or the municipality, through inaction, failed to implement adequate policies or procedures to safeguard its community members' federally protected rights. When, as here, a plaintiff pursues liability based on failure to act, she must allege the municipality exhibited deliberate indifference to the violation of federally protected rights. We agree with the district court that Park's Manel claim must be dismissed because she has not plausibly alleged the county's inaction reflected deliberate indifference to our 14th Amendment right to bodily integrity. So even assuming that they had a duty to act, they didn't act with deliberate indifference, which is a little bit odd because, they were there as their fellow officer pulled out the gun and was like, look at me, I wonder if this is loaded, and tried to load a revolver. Maybe I should try to recreate it right now on stream. I do actually own a revolver, so I could try to recreate this on stream and see how that goes. See whether or not I'm liable for that. That'd be good. Deliberate indifference is a stringent standard of fault requiring proof of a municipal actor's disregard to a known or obvious consequence of action. Deliberate indifference exists where there's a need for more or different action is so obvious, inadequacy of the practice is so likely to result in violation, policymakers of the city can reasonably be said to have had deliberate indifference to need. Park premises her claim against the county on the failure of the relevant policymaker, here, the chief of police, to address deficiencies in two Honolulu Police Department policies or customs mentioned earlier. As to policy 2.38, Park contends the chief of police failed to amend the policy to prohibit officers from carrying firearms whenever they consumed alcohol in any amount. As to the Brotherhood culture of silence, Park alleges the chief of police failed to implement mandatory whistleblowing policies, which would have rooted out the culture of silence. I don't know for sure, but I would imagine that even mandatory policies of whistleblowing might not necessarily always be actually followed by the police. So I don't know how much it would have actually helped, but sure. Park's allegations concerning Policy 2.38 assert the policy's facial deficiencies were so obvious that any reasonable policymaker would have recognized the need for reform. As Park reads the policy, it required off-duty officers to carry a firearm while consuming alcohol up to the point of impairment, a situation that would most certainly endanger the safety of anyone in the officer's immediate surroundings. We do not think the policy can be sensibly read in that way. Okay. First, the policy required that officers possess holstered pistols, which does not encompass taking out a firearm while doing so. Well, I feel real encouraged. So, yeah, it has. You have to have holstered pistols while you're plastered drunk. That's good news. Second, the policy's explicit purpose was to prohibit officers from carrying firearms while impaired. In no way directed off-duty officers like Kimura to carry their firearms with them when going to a bar to drink, an activity that could obviously result in physical or mental process becoming impaired because of consumption. Okay, if you say so. Park has not plausibly alleged the chief of police was aware of prior similar incidents in which an off-duty officer mishandled their firearms while drinking. In her complaint, she alleges only that, on 2 prior occasions, she witnessed Kimura drunkenly brandishing firearms in the presence of Naki and Asuma while drinking at the bar. So this is a bartender, right? So they have seen these people before. So this is not the first time this has happened. This is the 3rd time this has happened, and you keep letting them in and keep letting them in and drinking at the bar with their firearms at your bar. Wow. As Park acknowledges, however, the chief of police did not learn of the incidents before the injury. She alleges no other prior incidents would have alerted the chief of police that they were interpreting Policy 2.3 to require the conduct that endangered members of the public. Okay, pro tip to a wise. Pro tip to a wise. If literally anyone comes into your bar and starts drinking and then starts playing with a firearm, I recommend not letting them back in the bar. Just don't let them back in the bar. Police, no police, just don't let them back in the bar. Just say, we're not going to be serving you anymore. That would be a good tip. Because Park has not plausibly alleged the chief of police in action exhibited deliberate indifference to the federally protected rights, we affirm the district court's dismissal of the 1983 claim against the county. So that is the end of our coverage of the case of Hu Park versus Honolulu. In this case, we learned that 3 police officers on more than one occasion went to a particular bar and played with their firearms after drinking heavily. And on the 3rd such occasion in which this occurred, the officer pulled out their revolver and tried to load it, despite, it being loaded, and pulled the trigger, and it shot the bartender and caused grave injury. The bartender wants to sue. Now, they settled with the police officer, so good for that. But as to the other police officers, they didn't do nothing wrong. And as to the county, well, they didn't do nothing wrong because this wasn't part of their policies and wasn't part of law enforcement. So I don't know. I don't know if Naki and Asamo are going out to celebrate this decision in a Honolulu bar. But either way, that's the end of our coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.